Our first courtroom encounter occurred on December 3rd, 2024 in the Harris County Criminal Court in Houston, Texas. The footage shows Judge David Fleischer presiding over an arraignment and probable cause hearing for defendant Trevor Flores, who was charged with unlawfully carrying a firearm in a vehicle. An arraignment is typically the first formal step in the criminal process following an arrest. During this proceeding, the defendant is informed of the charges filed against them and advised of their constitutional rights. The judge also asks the defendant to enter a plea, usually guilty, not guilty, or no contest, and determines whether the defendant will be released on bond or held in custody. Now, in conjunction with the arraignment, Judge Fleischer also held a probable cause hearing. This type of hearing is intended to evaluate whether there is enough evidence to justify the defendant's continued detention and proceed with the prosecution. Unlike a trial, the standard at a probable cause hearing is not proof beyond a reasonable doubt, but whether there is a reasonable basis to believe that a crime has been committed and that the defendant committed it. Now, because Mr. Flores had already been taken into custody, the court was required to make this preliminary determination before moving forward. Probable cause hearings are especially critical when questions arise about the legality of the arrest itself, as was the case here, given that the traffic stop leading to Mr. Flores' arrest raised jurisdictional concerns.
Flores, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
Officers initiated a traffic stop after observing the defendant cross several lanes while failing to signal and almost causing a collision. Upon contact, the officers observed an odor of marijuana. The officers asked the defendant to step out of the vehicle and asked whether the defendant had marijuana inside. The defendant admitted he did have marijuana inside, as well as a firearm. During the search of the vehicle, the officers found a handgun in plain view on the driver's side floorboard, not in holster. And the officers also located 13 grams of marijuana under the passenger seat.
Got it. All right, Mr. Flores, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license? Do you not?
I have a SR22 in place. My license was suspended.
Okay, you're not allowed to drive. Do you understand?
Yes, sir.
If I find that you drive, I will have a contempt hearing. It's possible you face another 6 months in jail. I'm going to have you sign an affidavit with me today, promising you that you're not going to drive. Do you have liability insurance in your name? Car insurance?
Yes, sir.
I don't want you driving until you have a Texas driver license. You need to call DPS, figure out what to do to get your license. I'm going to give you the phone number now, but it's time for you to get your license back. And when you show me that you have your license and that you have car insurance, I will happily allow you to drive. But until that point, do not drive. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you understand? This is a condition of your bond. If I find that you have a weapon, I'm going to revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. Do you understand, sir?
Yes, sir. So I'm not allowed to retrieve my weapon back?
I'm ordering you now, while this case is open, not to have any weapons.
Yes, sir.
Okay? Here, Stephen, do you mind giving this to me, please? This is the number to the driver's license division to DPS. You need to call them in the morning to figure out what you need to do to get your license back. Give them your license number and ask them what you need to do to get your license back.
Okay.
Once you do, I'll tell you, I'll take this off, you know?
Yes, sir.
Did you want to apply for an appointed lawyer?
Yes, sir.
Okay, I need you to fill out an application for me. I'll take a look at it. And then assuming you qualify, I'll give you a lawyer today. I'm going to have you sign this agreement with me today that you're not going to drive. And I want you to understand, Mr. Flores, I take this so serious. Don't drive. If you drove here, you can't drive home.
No, I didn't drive here. My father did.
All right, so I'll have you come up here, swear to us. May I have you go to Jamay, sign a reset, and then we'll have you fill out the application. Okay?
Okay.
All right.
Judge
I'm
Fleischer
here for Francisco Hernandez.
Did you show up?
Yes, Judge, he's in the jury box.
Okay, what are we doing with Mr. Hernandez?
So he's set for a bond violation hearing. I don't believe that a bond revocation would be appropriate here. The basis of the violation is the drug test that he took on April 14th, which was the drug test that you ordered in court. And if you'll recall, he had a presumptive positive and you issued some new bond conditions. So
Not our first bond violation, is it not?
Well, so it is not. There was an earlier one for missing a drug test. However, the only basis for this one is something that the court already.
Come on, Mr. Hernandez.
You're right, Doctor.
So we ordered him not to use, right?
Yes, Judge. But he, with the, I mean, there is no evidence that he has violated that order after his drug test on the 14th, which you ordered.
Your Honor, the conditions requiring no drugs, no alcohol and testing went into effect in January 2025. Prior to the testing that we conducted in April.
So the conditions went in January.
Yes, Judge, I understand that, but this violation has already been addressed.
Has it?
Franklin University.
I don't know. Anthony, has it?
The court addressed it by issuing new bond conditions on the hearing on the 14th after the presumptive positive test came back.
No. So the client failed to report for a drug and alcohol test on 4/7/25.
Yes.
So we brought him in on 4/14 to admonish him and to tell you, hey, don't miss a drug test. When you miss test, that's when we issue warrants. Bad things happen when you do that. So he was ordered the next week to go take a test, and he now tested positive for alcohol. So that's where we are. So we've not addressed.
I don't believe that's completely accurate. It was not the next week that he was ordered. It was at that hearing. You had him go out and take a drug test on that day.
Is that right?
Judge, the violation that was submitted on April 7th was addressed for admonishment on April 14th. And yes, that was the day that he was sent to submit for testing. And then he had an additional bond violation submitted for being presumptive positive for THC. And now that was signed to be addressed today, which is what we're addressing.
Mr. Hernandez, I'm going to give you the benefit of the doubt. I've already had to put 2 people in jail now because they continue to use. You were begging for your bond to be revoked. No means no. Doesn't mean I have a party. Doesn't mean I have a graduation. Doesn't mean Jesus came down from earth and asked me to break bread. No means no. Do you understand?
Sir.
We are now at a stage of no tolerance. If you ever miss, if you test positive again, do you understand me? There's no excuse. And I'm going to, are you high right now?
So,
You can barely keep your eyes open, Mr. Hernandez. I want to test him again right now.
yes, sir.
I will test you 50 days from that test. And if you test positive for weed, that tells you that you continue to smoke and it's not going well. Do not use. Do you understand?
Sir.
From this day forward, you test positive. Okay, I'm setting for a test now.
And try to reapproach after that test is completed.
I know, let's roll it to tomorrow because it's now 12 o'clock in here. Okay.
I'm here for Francisco Hernandez.
Okay.
He's here for a bond violation.
Okay, come up, Mr. Hernandez. It's Hernandez or
Mr.
Roxanne. What
We were presumptive positive for THC.
That's it.
That's it.
Okay. I'm giving you a pass for 50 days from the time that we ordered you not to use. Don't use. Do you understand? So we ordered him not to use when? He's still testing positive. We ordered him not to use in January.
He tested positive on April 7th, Judge, or not, on April 14th, rather.
Okay, but he's still testing positive. He's still using when we ordered him not to use.
Yes, Judge, but I understand that THC can take up to 30 days to work out of urine, so there's no evidence that he's been using beyond the,
I ordered him not, let me see, hold on. I ordered him not to use in January. We are now,
yes, Judge, but you've already addressed his drug use that resulted in the positive result on the April 14th drug test. You addressed that by chastising him in court and issuing several additional bond conditions. There's been no evidence that there's been any additional drug use for the court to address.
if I tested him in early January, then I'm going to have an issue. But if it's the first time I tested him was in April, then I'm going to give him the 50 days from the first time that we tested. But if I tested him early on and he tested positive and I admonished him not to use and he's still testing positive, I'm going to have an issue. I don't remember when the first time we tested him, so I'm going to ask her. Roxanne, Mr. Hernandez, when was the first time we tested him, please?
When he first tested positive for THC,
Yeah, when did we first test him?
Oh, it was March 11th of this year.
Okay. So March 11th was the first test, and that was positive for,
Negative.
that was negative.
Yes, it was negative. And then on April 7th is when it was a no-show. And on April 14th, it was confirmed by lab that he was positive.
No, you're using. I'm sorry. I'm revoking your bond. You're going into custody.
I could just ask the court to consider, so, Mr. Hernandez's mother is out in the hallway. I'm certain that she's going to pay whatever the bond is. This, revoking the bond here will only have the effect of punishing, his mother, who will have to pay the bond. And I'd also just ask the judge, you to consider that I understand that there may be evidence that he's used since he was ordered to not use. I understand that. But, there's no evidence that he's using now or that he has used in the more than 2 weeks since the prior drug test.
We just tested him yesterday. He tested positive. He tested positive a week ago. I've ordered him not to use. I mean, if I don't, then I'm rewarding him for his behavior, Mr. Schlossberg. That doesn't make any sense. You know, I understand that it's punishing mom. These are the things that you need to consider when you're out there. I told you not to use, and you're now using. Goes with you. I'm sorry, Mr. Schlossberg. I can't just continue to let people go.
Judge, the drug test yesterday, it came back positive for THC because it was within 14 days of the previous drug test on the 14th.
He tested negative the first time we tested him, and now he tested positive for using marijuana. That's it. There's no, I mean, really, if I don't, I'm enabling the behavior, and that's it.
Yes, sir. May I excuse, please?
All you said is there's an accident and she had missed one beer. Was there any slurred speech, bloodshot eyes, odor of alcohol?
Sure. In summary, but it looks like we just have the car crash and the admission of the one beer.
Good morning, ma'am.
Good morning, Rona.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Okay. On July 27th, 2024, at about 9:20 p.m., officers arrived on scene and observed two vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant's car. The witness stated she saw the defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having one beer. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turns, a 3 out of 4 on the one-legged stand. The DIC was read and the defendant considered to a breath test. The first result was 0.175 and the second result was 0.181.
All you said is there's an accident and she had missed one beer. Was there any slurred speech, bloodshot eyes, odor of alcohol?
Sure. In summary, but it looks like we just have the car crash and the admission of the one beer.
Good morning. Can you hear me?
Judge, can you hear me?
Yeah. Can you hear me?
Yeah, I'm here. Yes, sir. I'm sorry. I'm down in Galveston. Yes, sir. I'm here on Mr. Morales.
Yeah. She's actually right in front of me right now, Michael.
I see it. Perfect. That's why I jumped on.
Have you heard PC yet?
No, sir.
All right. Do you mind reading it one more time?
Absolutely, Your Honor. On July 27th, 2024, at about 9:20 p.m., officers arrived on scene and observed two vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant's car.
The short answer.
The witness stated she saw the defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having one beer. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turn, a 3 out of 4 on the one-legged stand. The DIC was read and a breath test was given. The first result of 0.175 and a second result of 0.181.
I didn't hear anything about any kind of slurred speech, odor of alcohol, bloodshot eyes. I didn't hear any of that, Michael. So I'm just finding no probable cause.
Okay.
You know, Ms. Morales, we have enough destruction on our streets, enough death from DWIs every single day. You know, just don't kill someone, please. If you're going to drink, if you want to have 15 beers, 32 shots of tequila, one button on your phone, $40 with an Uber will get you anywhere you want to go. Use it. Please.
Yes, sir. Thank you, Judge. I'll talk to you later.
Thanks, man.
Take care.
Trevon Frazier, come up. Why? Why would we do this? You know,
Regular motor vehicle is not guilty of, Judge. We provided exoneration. Yes. Material for that. He had an alibi defense. He was at work when that offense occurred. The theft case came from the burglary motor vehicle because he used that person's phone for cash out. So he's pleading on the theft and the burglary motor vehicle is being dismissed.
theft after robbery, after gun case, after trespass, now working 1, 2, 3, 4, 5, 6, 7, 8. Why would we just continue to take these proverbial slaps on the wrist when you continue to pick up cases? Not only that, you can't even keep up with bond conditions because he has a bond violation, right?
Judge, he had bond violations and he revoked his bond. He spent 18 days in jail. He was going to stay in jail. His girlfriend bonded him out this past weekend. He didn't have phone service, and that's why he didn't go to take the drug test on Monday. And as soon as they contacted me, I contacted him, told him to contact pretrial, and they told him he needed to contact me again. But he did not have phone service, and when they notified him, he needed to be there Monday. He didn't receive any new bond conditions after he bonded out because it was on the weekend. But he would have tested had he known he had to be there. He contacted me immediately.
People don't get it when it comes too easy. When you continue to get these proverbial slaps on the wrist, you just don't get it. All I care about is my city. All I care about is protecting everyone. And here you are with working 8 and 9. Now another proverbial slap on the wrist. How does that benefit anyone? What have you done to change your life? What have you done? What are you doing right now, Mr. Frazier?
Oh, I'm going back to work. Like I said, my system should be clean, so I'm trying to get my tweet card and get back in the.
Someone's got a case of the spostas. You got a case of the spostas. So I'm supposed to do this. I'm supposed to do that. I'm supposed to do this.
This is what I'm doing now. I just got out of jail Monday, so I'm trying to get my life back together. That's all. That's what's going on right now. I'm in the process of doing that. I'm going back to work tomorrow. I just wanted to come to court. My boss lady said she wanted me to come to court first before I just came back to work and had to miss work again.
I think that probably the only way that I would do something is that I can hang on to you tight to make sure things are done the right way. So I know you're doing right. This, you just end up with just a bunch of more convictions. And now, the next time it's a felony. If I take this, which I'm telling you, I'm not going to, the next one, you're looking at a felony and you're looking at years instead of days. And with probation, I'm okay, but sorry, I'm just not going to do it, Mr. Frazier. I want to make sure that you end up on the up and up and just don't become another statistic. And this, you're just another statistic, and it's not going to happen. I'm sorry, Carl. If you want to do probation, I'm happy to do it. That way we can maintain and make sure he's doing right. But talk and let me know. So you can withdraw it. We can set up a trial, or you guys want to work something else out. I'm happy.
At first glance, this looks like an open and shut DWI case. There's a crash. The driver admits to drinking. Field sobriety tests are completed, and the breath test results appear incredibly high. Most people would expect the judge to immediately find probable cause and move the case forward. But that's not how Judge Fleischer approaches the law. Instead of focusing only on the breath test numbers, he starts asking a simple but critical question. What did the officer actually observe? Were there signs of intoxication, like slurred speech, bloodshot eyes, or the odor of alcohol? When those details are missing from the police report, the entire case suddenly hangs in the balance. Watch closely, because this hearing becomes a powerful reminder that in court, every detail matters. And even a seemingly strong DWI case can unravel when the evidence isn't properly documented.